Good morning. Welcome everyone to this, the second meeting of the Justice Committee in 2014. I ask everyone to switch off mobile phones and other electronic devices completely as interfere with the broadcasting system, even when switched to silent. No apologies have been received, but I welcome yet again Graham Pearson to this meeting of the Justice Committee. Not at all. I go to item 1. The committee, I'm inviting you to agree to consider items 3 and 4 in private. Item 3 is consideration of a draft report to the European Committee on our EU work in 2013 and discussion of our EU engagement plans for that year. Item 4 is consideration of a draft report on the LCM relating to, in particular, to forced marriage. Are members agree to items 3 and 4 in private? Agreed. Thank you. Our next item is our second evidence session with the Cabinet Secretary of Justice on the Criminal Justice Scotland Bill. The Cabinet Secretary will give evidence today in corroboration and related reforms, such as the jury majority, admissibility of statements and sheriff and jury proposals. These provisions are contained in parts 2 and 3 of the bill. We'll start by looking at the provisions on corroboration and related reforms and admissibility of statements. And can I say, for the benefit of all the witnesses and the Cabinet Secretary, and indeed myself and the committee, we'll have a 5-minute break after we've done that batch and then move on to the next sections. So I welcome to meeting Kenny-MacAskill, Cabinet Secretary of Justice, and Scottish Government officials, Iain Hockenhull, Policy Manager, Criminal Justice Bill Team, Elspeth MacDonald, Deputy Director, Criminal Justice Division, Lesley Bagha, Bill Team Leader, and Kathleen McInulty, Policy Manager in the Bill Team. I understand, Cabinet Secretary, you wish to make an opening statement before I open up to questions from the members, please.
Thank you. Last week we discussed the Bill's proposals for reforming police powers and increasing the rights and protections for persons accused of crime. And today we address protection of the public. Abolition of the corroboration requirement is an essential and long overdue reform. It is at the very heart of a bill seeking to ensure justice for all members of society in 21st century Scotland. I do not seek conflict with the legal profession. As a former practitioner, as an MSP and as a citizen, I am proud of our system. However, as Justice Secretary, I have to consider the interests of all society. If we cannot protect the vulnerable, then we as a society have failed. We have a duty to provide an effective justice system for all citizens, not just those whose cases happen to meet complex corroboration rules that even judges find confusing. Committee members will have heard the significant concerns aired about justice being denied because of the corroboration rule. Brave individuals have spoken out, backed up by organisations such as Rape Crisis, Victim Support Scotland and Scottish Women's Aid. ACC Malcolm Graham spoke passionately here about 3,000 victims every year whose cases do not even get submitted to prosecutors. And a UN committee has highlighted its concern that the requirement impedes the prosecution of sexual offences. I know some members have challenged witnesses to make positive suggestions on what can be done. I don't wish to dwell on the deficiencies of our rules on corroboration. You've heard how it has been stretched and eroded and circumvented in order to cope with hard cases which have made for a bad law. You've heard that no other comparable system has this general requirement, which in some cases onerous and which is in others, in the words of the Law Society, and quote, whittled down to the bare minimum. Few would adopt a corroboration rule in designing a system from scratch. Ensuring cases are high quality must surely be the focus of a modern criminal justice system. Scots have every right to the same degree of access to justice enjoyed by their neighbours. I know some have concerns. There seems to be a popular view that abolition will mean prosecutions based purely on one person's word. That is not the intention, nor is it that of the Lord Advocate. Simply looking at other systems should provide reassurance here. Their courts are not awash with case based upon a single source of evidence. The Lord Advocate has said that he will require supporting evidence to bring any case. So let me make clear what is meant by supporting evidence. It means allowing cases like the examples presented by the Crown Office to go forward. I think most people would agree those examples feature enough evidence to merit a court hearing. The second, for example, features the victor's testimony, her distress, her special knowledge of the accused's distinctive underwear and her description of the scene. But there's no corroboration of the alleged indecent assault. This case could not proceed in our country, but it could in others. This is what I and the Lord Advocate mean by supporting evidence. I appreciate that many of those calling for further study are not wedded to the past or resistant to change or unsympathetic to the plight of victims. But a further review of whether the corroboration rules should be abolished would take us no further. We would hear the same voices in the same terms. we would hear the same suggestions, and in the end I would, I'm convinced, still be looking at the same recommendation to remove the requirement from our law. In the meantime, the manifest injustices would continue. The Lord Advocate shared his personal experience of some of the hundreds of strong cases denied a hearing every year. We cannot wait for a further 3 or 4 or 5 years to address these injustices. We need to hear those who have been suffering in silence behind closed doors. The elderly victim who is robbed by a bogus collar. The person who suffers day in, day out at the hands of a violent partner. The rape victim attacked in her own home. And we need to give them access to justice as soon as we can. And although I am passionate about the need for reform, I will respond to constructive suggestions. I met with several stakeholders over the festive period, and I look forward to the committee's Stage 1 report. But I do not doubt my commitment to seeing the corroboration rule abolished. The provision of justice is not a game. This is about getting it right for everyone, society, victims and accused. And I repeat that I remain open to constructive suggestions, but I cannot stand by and allow our system to perpetuate the disregard for those being denied access to justice.
I thank the Cabinet Secretary, though I would have to say I don't think anybody in the committee considers the abolition of corroboration is a game. I think we take it very seriously indeed, and that's why we're taking trouble over this very important issue. John Finney, followed by Elaine Murray, followed by Roderick, followed by Christian, followed by Sandra, followed by, well, it's John, then Sandra, then... Did you get that, Alison? Yeah. I wonder why they're so interested in asking questions. They don't normally have this flurry. John.
Thank you, Convener. Morning, Cabinet Secretary. Cabinet Secretary, the Scottish Human Rights Commission described corroboration as being a legal safeguard. And similarly, the Lord President described it as one of the great legal safeguards in our criminal justice system. Is it for that reason that you propose to alter the jury numbers?
Well, can I just put on record, I think the mentioned game actually came from Derek Hogg QC on a programme on corroboration, and I think it's referred to in a letter from Colette Barry that was sent to the committee, and she refers that it is not a game to her. It's part of, as I say, a suffering that she sustained, and I think it will be part of the evidence that the committee have as a letter from Colette Barry. But with regard to the Human Rights Commission, I met recently with Professor Alan Miller and Sheila McCall, and it was very useful and helpful, and it ties in with, we're happy to consider any additional safeguards. That's why we went out, and I think that, yes, one of the bases for seeking to change the jury majority from 8-7 was about an additional safeguard to protect, because this is always about ensuring that the scales of justice are balanced. We have to protect the rights of the accused as well as the rights of the victim. I believe that corroboration impedes the rights of the victim. I also believe that if we remove corroboration, we do have to ensure that we do make sure that the scales are calibrated appropriately. And one suggestion has been, and I'm comfortable with, moving to a two-thirds majority. That seems to me to be a reasonable position to be in.
If that's one way of addressing the removal of corroboration that applies to solemn procedure, what additional safeguard or alternative safeguards have you put in for solemn procedure?
For summary procedure, you mean?
Summary, I beg your pardon.
For summary procedure, again, I think these are matters have to be considered by the Shrevell bench. We are happy to consider any additional safeguards. For example, the suggestion made to me by the faculty advocates in discussions, we have to consider doc identification. I think, frankly, that's probably long overdue for consideration. So we're open to considering any such suggestions as this. The other references made has been considering whether matters should be removed from the jury. That doesn't obviously apply to summary. So we're happy to look at any additional safeguards, but the additional safeguards that have come in so far have been doc identification, and I'm perfectly happy to consider that.
But you have put a proposal in place in relation to solemn procedure, but you haven't put any alternative proposal in place in relation to summary procedure.
No, because these are the safeguards that we went out to consultation on. They were approved by the Senators of the College of Justice. And as I say, I met with Sheila McCall and Alan Miller. I think they're not so much looking for additional safeguards. I think where they're coming from is perhaps how the system operates in the new landscape, if we can put it that way, because some of that would be down to judicial training through the Judicial Institute, but the position remains we're open to any additional suggestions of safeguards, but so far few are being forthcoming.
But the reason safeguards is mentioned is because it's frequently said that the Scottish system is the only one where corroboration is retained. But other systems where corroboration doesn't necessarily apply have alternative safeguards. Is that not the case?
No, well, again, I'm looking at those potential safeguards, but nobody can really suggest. The closest I've come to it, and again, we were discussing it with academics, I mean, there's a system in the Netherlands, which is where I think, actually, the Lord Advocate wishes to get to. In the Netherlands, there requires to be additional evidence. That's why I think the additional safeguard that may be suggested, it hasn't been, but I'd be open to it, would be to put the prosecutorial test on the face of legislation, and I would be open to that. The Netherlands system is not corroboration in that it doesn't require throughout the whole strand of evidence, but it does indicate that for a conviction there has to be additional evidence beyond, as I say, the principal matter, whether that's confession or the main substantive piece. That seems to me where the Lord Advocate has indicated he wishes to take the prosecutorial test, with the quantitative and qualitative test, with the evidential and prosecutorial test. So it seems to me that the additional safeguard, if you wish, that would be available would be to put that on the face of legislation and actually enshrine what has to be proven before there can be a conviction.
The Police Staff Association's position seems to support yourself, and they obviously have taken reassurance from the Lord Advocate about the protection that would be afforded their members prior to any prosecution being instituted. Now, that's the same for the teaching profession and social work profession, quite rightly so. What protection is there that the Lord Advocate can give the unemployed labourer?
Well, I think what we have is the assurance. I mean, there are specific instances for those professions, given the, I think, the consequences that usually run into other organisations and other challenges in their employment with parallel investigations going on. The assurance you have here is that safeguards can be brought in. If there are safeguards that you think exist in other jurisdictions that aren't referred to, then I'm quite clear I'm happy to have them invoked. So far, the suggestion has been Doc ID. We're also happy to look at putting on the face of the bill the prosecutorial test. But I think beyond that, it would be for others to state what there is there. Equally, it would be fair to say that that system seems to operate fairly and balanced in the 47 countries that sign up for the European Convention of Human Rights. Scotland is unique and is alone in its current system, but the additional safeguards that I've mentioned, I'm happy to sign up to. If there are additional safeguards that you think should be brought in, then I would ask you to specify them, and I'm more than happy to seek to implement them.
Do we take from that, then, Cabinet Secretary, that you'll be, the Scottish Government will be proposing amendments in the form of additional safeguards?
Well, it's always been our intention that we would seek to bring in amendments to update and ensure that safeguards are there. I think at the present moment, as a government, we've made clear our commitment that corroboration has to go, because it is denying access to justice for not tens, not hundreds, but thousands of people on a yearly basis, and therefore it's unacceptable. But I give the commitment that we have to have the scales of justice properly calibrated, and on that basis it has always been our intention that there would be, as I say, amendments to provide greater safeguards. We're discussing and looking to have those safeguards confirmed or clarified, and I'll be looking to hear from the committee what additional safeguards you wish to suggest, and I give you a commitment that we'll be happy to look very favourably at them. It's also the reason that we've been engaging with other stakeholders, and it's through these discussions that, for example, Doc ID has been brought in as a clear situation where there has to be some change.
In solemn procedure, would you favour the no-case stance, or the judge being able to not refer the matter to the jury?
I'm perfectly comfortable with that. It was a situation before that got changed. I'm frankly relaxed about that, but I could see some good reason why it should be within the power of the judge to take it away from the jury if he or she believes that there is clearly insufficient case to go forward.
What would be your understanding of...
I think, in fairness, can I let some other committee members in and let you come back?
Yeah,
I've given you quite a long whack at it. Yeah. You've had about a quarter of an hour, so in fairness. Could I have Elaine, please?
Thank you, Convener. Can I just start by saying that I and all other members of the committee, irrespective of our views on the abolition of the requirement for corroboration, are all equally concerned about the lack of delivery of justice to people who are victims of sexual crimes and domestic abuse. Can I, first of all, return to a point I think that John was referring to? I mean, obviously, the lack of the abolition of the requirement for corroboration would apply to the trade unionists on the picket line, the protester on a demonstration, as well as to the victims of those types of crimes. Are there no concerns that you have about civil liberties?
Because I think I'm satisfied with where the Lord Advocate is coming from, that what will it be? The case is simply one officer saying the crime has been convicted is inadequate, that there will always have to be additional supporting evidence. That will always be required before the case will be brought. And I think if there is that additional supporting evidence, then I think that provides some backstop along with any other safeguards. But I think the requirement for 2 or more, and indeed if there are 2 or more, they'll be brought. But as I say, no case will be brought without additional supporting evidence.
I think the problem is, though, that is the word of this Lord Advocate. That doesn't tie any Lord Advocate in the future. It's no longer in legislation, so it ties nobody. It is only a desire of this Lord Advocate and this Cabinet Secretary, isn't it?
Well, that's a fair point, and that's why I'm perfectly happy to have an amendment to put it on the face of the bill.
Can I just ask, if you haven't asked, what, in that instance that Elaine Murray gave, what would supporting evidence be as opposed to corroboration? The picket line and the police officer?
That would ultimately be for the Crown to decide. It could be CCTV, it could be... I mean, I think all these things depend on context. Normally there would be more than one officer there and they would be speaking to that at a melee, whether it's a picket line or a football game. What the additional evidence would be, I think, would be required to be in the context and the circumstances, but what you have an assurance of from the Lord Advocate and from myself is simply the word of one individual will not, of its own, be enough.
Surely that's what corroboration is. It's supporting evidence. It's not necessarily a second witness. It's supporting evidence.
Well, I think the difficulty is we don't know what corroboration is. I met 2 of our most senior academics, and I asked them if they could give me a 1 or 2 page synopsis of the law of corroboration. And they admitted that they couldn't probably get one that would agree. I think it's quite clear that we have difficulties in the judiciary being able to agree what corroboration is. If the committee can tell me what corroboration is and actually agree to it, then that will probably be some progress.
Would that not have been an alternative then to the abolition of the requirement, but actually to seek some sort... I mean, you mentioned in your opening statement it was complex corroboration rules and they'd been stretched and eroded and circumvented. Now, wouldn't an alternative not have been to seek for somebody like the Law Commission to actually draw up a definition of what counts as supporting evidence, so that you could possibly include such things as the distress of the victim or special knowledge as contributing towards corroboration? Would that not have been an alternative to abolishing the requirement, but to actually have a stricter definition, a recognised definition of what counts as corroboration?
Well, I think there's there's 2 arguments there. One is, should we not be abolishing, corroboration? I think the case against corroboration is made. I think that when we have not tens, not hundreds, but thousands of people every year not getting access to justice, there is a clear impediment. It is not simply rape and sexual offences, as the Solicitor General has commented on. Many elderly and vulnerable people, it's been raised by Sandra White, whether they're victims of assault in their own home and care homes, or whether it's those who perpetrate some scamming offences on the elderly, whether it's children. People are being denied access to justice. It's why every organisation that appeared before you as a giving evidence as a victims organisation, Scottish Women's Aid, Victim Support Scotland, Rape Crisis Scotland, were quite clear. So I think the case against corroboration is made. I can't see how you can tweak it. What I do accept is that there can be and has to be something appropriate in terms of getting these safeguards right in the new landscape. We have been and are open to consideration of further, safeguards. We are open to how it operates. We are open to it being placed on the face of the bill. All of that we are perfectly comfortable with, to make sure that when we move, we do not move one manifest injustice for one side of the equation, replacing it with a manifest injustice for the other side of the equation. But the status quo is not tenable. I firmly believe the case against corroboration is proven.
I don't know, Cabinet Secretary. I mean, I may just be a simple-minded scientist. I'm not a lawyer. But I don't understand the difference between the supporting evidence that the Lord Advocate requires and the supporting evidence which will be required for corroboration. I mean, to me, they sound like the same thing.
No, because corroboration, without me trying to get my own interpretation of it, does require a view throughout the whole link of the case from the very beginning through. That's why you have to have two forensic scientists speaking to a sample, why you have to have two police officers speaking to the collection of the CD-ROM from London. All of these things have to be done because it's part of the integral thread of the case. What the Lord Advocate is talking about, what, for example, happens in the Netherlands, is you're talking about the principal evidence that goes to court. I mean, if people can tell me why we do have to have two forensic scientists signing off a label when the matter is not being challenged, I'm open to being, persuaded. But that is what is necessary according to the rules of corroboration when it's part of the fundamental aspect of the case. That's why, as I say, corroboration cannot be tweaked with or altered, why we have to get rid of corroboration. But in doing so, we have to make sure that the safeguards, the checks, the balances and the operation of the system is appropriate.
Two police officers are the two forensic scientists. That's the issue as far as domestic abuse and rape cases are concerned. It's the supporting evidence. It's a definition of what supporting evidence would corroborate their statement.
Yeah, but that's not the law of corroboration. The law of corroboration requires not simply what happens in the court case. It requires matters throughout.
We appreciate that. I think if we, and understand your argument about the threads that lead up to the court case, but I think if we focus on once it's in court, I'm concerned, along with others, that the discretion or the flexibility that exists for corroboration, I think the same thing will happen with what is or is not supporting evidence for the judiciary. They'll decide in the same way. There is to me, I agree with my colleague here, I cannot see in the court context the huge distinction, if any, between supporting evidence and what now in the widest way will be admitted as corroboration.
Well, that's probably
in the circumstances of each individual case.
Probably because we've got difficulties, which is why academics and the judiciary have difficulty in actually announcing what corroboration is.
Will the same issues, Cabinet Secretary, not also then pertain to supporting evidence and what the judiciary concludes is sufficient supporting evidence in the case? It's not as if it seems that we're changing labels to some extent.
No, I think what we're looking to do is probably start afresh, which is why we looked at the safeguards. Corroboration, let's remember, when it was brought in, was when it was actually meant to be two people speaking. It has since been ameliorated, watered down. So is it two people? No. What is it? Well, it depends on the circumstances. So it's been ameliorated, understandably, for the right reasons, to provide flexibility, whether it's in Murov, whether it's in a variety of other things. I think once you get away from the view that corroboration has to be there, with all the difficulties that it causes, from the very beginning, with a duplication of resources that we heard from ACC, Graham, with individuals having to do all this, right through to the impediment of justice and not even getting into the court arena because you don't have corroboration of the indecent assault, as we've seen in terms of evidence put forward by the Crown of the young girl assaulted, able to identify the perpetrator, apprehended, wearing underwear that is distinctive. That clearly seems to me to be supportive additional evidence. Why would that girl know? How would she make it up? Was it just pure chance? Well, that might be something the jury would decide, but that doesn't even get to the jury. It doesn't even get into court as we currently stand. So, as I say, that I think shows why the case against corroboration is proven. What we then have to do is to ensure, but there will always be case law that will come up in the world in which we live, in the common law system in which we operate. The court will always have to interpret the law and set rules. But clearly what can be done is to set down, the matters that the committee and others feel necessary, not just the size of the jury majority, whether the prosecutorial test should be enshrined. All of these things can be enshrined to make it quite clear, but I think you'll always have to have some flexibility for the judiciary, because every case, every offender is different, every case is unique.
Yes, we understand that. Iain, you finished just now? I'll take Roderick, please.
Good morning, Cabinet Secretary. In the supplementary written submission from the Crown Office, paragraph 4 says it's important to be clear at the outset the abolition of the requirement for corroboration is not about improving detection or conviction rates. When the Lord President gave evidence before us, he said that was a rather simplistic statement from the Crown. Then he went on to discuss matters which I think are largely incorporated in the new prosecutorial test. But he said if it's simply a matter of giving access to justice, I have to say it's not my understanding of the Lord Advocate's role. Of course, I might be wrong. Could you just clarify what the government's thinking at the present time is in terms of the question of detection, conviction rates?
Well, conviction and detection rates are for the police and ultimately for the courts. We are coming from the view, and I agree with the Lord Advocate, this is about access to justice. I come back to the letter sent to the committee by Colette Barry. She wanted access to justice. When I met with her, she was quite clear. She would hope that that would result in a conviction. She would be disappointed if it didn't, but she would accept the position and the view of the jury. But she had been groomed and abused as a child, as had her sister. She had had to live with the consequences. They had affected her, despite the fact she's a bright, intelligent woman. It had affected her whole life in very tragic ways. She wanted her day in court. She wanted, as she said to me, to look her abuser in the eye and say, "You ruined my childhood and you've damaged my life." She would be deeply disappointed, but she recognises, I can't make up the mind of the jury. The Lord Advocate can't make up the mind of the jury. That's the decision of the jury. Sometimes the jury might make a decision that would be unacceptable to her, but she would at least have her day in court. And as she put it to me, she wanted to be able to look her abuser in the eye. She wanted access to justice. She knows that we can't deliver beyond that. It's for the judge or the jury. This is about access to. She does hope that more access to justice will result in more justice being delivered. But the decision of the court will be for the judiciary and for the jury. But access to justice is about giving the Colette Barrys some opportunity to have some closure for what's happened to them.
Thank you, but you would accept that in terms of conviction rates, it's really a matter of speculation as to what will happen.
Absolutely. There is, I think, we have no control over that, rightly so. What we can have some control over is whether these cases get to court. The 5 examples put forward by the Lord Advocate, including that wee girl, a jury could come back and say it was just happen chance that she knew what his underwear was. These things happen. That will be for the jury. The jury could come back and say that perhaps the woman who had been raped, well, maybe she did know him or had invited him in or it had been consensual. I don't know what defence would be run by the accused. But, as I say, what we do have control over, what we can do as a legislator is allow access to justice. What we can't do as a legislator, because that rests with the judiciary, is actually make a decision as to whether there's guilt or innocence. And we clearly have to have that separation of powers. But if we don't give access to justice, then we're not giving the opportunity for there to be closure for all these victims.
Thank you. Just moving on to the question of safe...
Move on. You refer to them as victims, and we know that we've got to be very careful with the language here, because until it's proven, of course, they're not victims, notwithstanding some of the horrors of some of the examples you've given. And what about the concerns about access to justice for the accused in these? You talk about the balance, recalibrating. There have been instances where there's been false accusations, and the concern might be that if you have these accusations coming to court, there's trial by the media, and notwithstanding what happens at the end, an acquittal, or indeed, if we keep it not proven, somebody else's life has been ruined.
Well, what we have to do is to ensure that we have the adequate safeguards. And as I say, that was raised by Mr Finney, and I've mentioned discussions that I've had with other bodies, and I'm open to any additional safeguards. The door is open, and I welcome the comments that the committee will make on that. Equally, I think it's quite clear from discussions with many, it's not simply the number of safeguards, because probably when you look around other Western European, Western democracies and even, other Commonwealth countries, the additional safeguards that they had there probably aren't that great. It's how everything stitches together in terms of where we're coming from, but we're happy to look at that and to make sure that we take time to get it right. But as I say, what we do have now is the opportunity to give access to justice to victims. In terms of publicity, that's a matter where the courts do have some powers. It's a matter touched upon by other commissions and inquiries elsewhere. In terms of this criminal justice bill, this is about getting the balance right, and I accept that corroboration does resolve matters, I believe, in access to justice for victims. We do have to ensure that we provide adequate protections, not just safeguards, it's the protection for the rights of the accused.
Sorry.
I welcome what you said this morning, Cabinet Secretary, in relation to the position in relation to safeguards. One of the things that slightly troubles me, though, is that obviously Lord Carloway took the view there was no need, if the requirement for corroboration was abolished, for any rebalancing by the introduction of further safeguards. And the Lord President, in his evidence on the 20th of November, said if there's a good solid intellectual case for abolishing corroboration, there should be no need for any safeguards. The moment we say there have to be safeguards, we're conceding that the change creates a risk of miscarriage of justice, which in my view it will. It's obviously of some concern that the kind of two leading figures in the judiciary are taking what I consider to be a slightly negative view on the issue of safeguards. If you have any comment on that.
Well, because I think actually it's coming towards that there have to be additional safeguards, and I'm happy to accept that. They're not perhaps, they could be, as Elaine Murray was saying, and we're perfectly comfortable, and I think there would be good reason to put the prosecutorial test to enshrine it and to protect it from political changes. So I don't think it's necessarily the number of safeguards, it's how things operate collectively once we remove corroboration. But equally, I think there's also an acceptance. A lot of the requirements for corroboration that I've mentioned are the prelude, because it's not simply what happens on the day in court. I think there's an acceptance, across a lot of the political chamber that, yes, it's daft that two police officers have to go down to London to pick up a CD-ROM. Yes, why do two, forensic scientists have to sign off a label? Well, they're core. So I don't think you necessarily need to counterbalance the safeguards there. What we do have to do is to ensure that when we have the court hearing, when there are the corroboration, albeit ameliorated from the days of two eyewitnesses, is gone, what is it that is necessary? So we have to ensure that we have that enshrined, and we have to make sure that any other issues, which I think have correctly arisen, such as doc identification, which I have to say I've always been somewhat sceptical about, are properly analysed, and we're happy as an administration to make sure that we review appropriately, take time to get it right.
Just in terms of timing, Cabinet Secretary, why do you think it's important for this reform to take place now?
Well, as I say, I think the reason that we have to do so now is that Lord Carloway was asked to go away and carry out a review following the Cadder decision. He has done a review and given us the opportunity for a criminal justice bill from the point of first suspicion through to the point of final appeal. And I think the benefit of this is to get it laid out in the one act. Secondly, when we have not tens, not hundreds, but thousands of victims of crime denied access to justice on a yearly basis, then we require to act. So I think that this opportunity is now here with Lord Carloway's view. What we do, and where we are quite comfortable about taking some additional time to get it right, is to make sure that the new landscape, the new evidential regime is right and fit for purpose before it's good to go.
Thank you.
Thank you, Roderick. Just to make people know that, Graham, you're next, followed by Christian, John Pentland, Sandra White, Alison McInnes and Margaret. And then John Finney if you want back in. Or if you've got supplementaries. Graham.
Thanks, Convener, and thanks for letting me in. You mentioned the Cadder result, and that was a decision taken by the Supreme Court, the Supreme Court that Lord Hope was a member of. Lord Hope gave the judgment and has recently gone public in indicating that he thought that the current administration approach to corroboration and its abolition as a principle was wrong. So his voice, in terms of his view, is joined by the Lord President and many other very significant people within our community. Even Mojo have come on side in indicating their concerns. So this is a controversial issue and one that causes concern. Is there time to take breath and not lose years over the next stage, but at least take the next months to ensure that we have the approach right and that we have the process of delivering justice balanced? We talk about what checks and balances can we put in place. Corroboration was one of those checks and balances in the current system. And it doesn't sit well to merely call it an outdated technical requirement. It's actually part of a process that's taken hundreds of years to hone down to its current situation. Have you taken time to think about whether or not the Scottish Law Commission or some other mechanism could be utilised to look at the judge's powers, the size of a jury, never mind what a majority looks like, the not proven verdict, the use of hearsay within a trial, the docker identification you've spoken about, the impact of corroboration you've mentioned in forensic science and post-mortem analysis. I mean, there are minutes of agreement now that don't require two witnesses to come forward. Is there time to stand aside from this at this moment and get this right for everybody concerned?
I think there's time to get the new system of evidential requirements and the other aspects that you commented on right. I don't think there's any time to delay in getting rid of corroboration. The archaic view of it came not from me but came from Lord Carloway. I know the other senior judiciary disagree with him, but let's be clear, Lord Carloway was the only judge who went away, spent a year investigating this. None of the others did, and he came back and was persuaded of it. I have listened respectfully to Lord Hope. Equally, I also remember that in no stage, when sitting on the Supreme Court of the United Kingdom, and indeed other places, whether in the Commonwealth, Caribbean or elsewhere, has it ever been suggested that corroboration should be brought in England or Wales or Northern Ireland or San Lucia or anywhere else? So I believe the case against corroboration is made where we do have time to make sure that we have the system right, that is the best possible system that it can be, which would, as I say, I think, give good merit to it, because it does seem to me that whether it's the Netherlands or Germany or other countries, the other countries are not awash with manifest injustices. They seem to me to be actually quite, decent democracies that sign up for ECHR. They don't have corroboration. So I can certainly give you an assurance, Mr Pearson, yes, we can take time to get it right, but I don't think we can delay in getting rid of corroboration.
Graham, you say Lord Carloway took a year out. Did the rest of his review panel take that year as well? Were they not out doing it too?
Well, they were a reference group, so
the reference group, they spent a long time over it too, did they not?
Well, I don't know. It's only Lord Carloway that I've discussed, but the reference group are there to engage with him.
Yes,
he was doing nothing but that.
Yes, but it's just to appreciate the reference group. We were told that the vast majority opposed the abolition of corroboration, so it wasn't a one-man team. There was a team there as well, and that, just for clarification.
I think that Lord Carloway did take the year out. He was a member of the bench at that time. He's since been promoted to his current situation. We've got a huge number of people with similar experience to Lord Carloway, and some might argue far more experience in terms of the administration of justice in Scotland, who take an alternate view, which really causes concern to people like me when trying to come forward with the right way forward. The other point that you make about other jurisdictions, I did a very brief review of miscarriages of justice in England and Wales. I've got 62 people here in the recent decades whose cases were found after many years of imprisonment to have been miscarriages of justice. Thankfully, that's not been current in the Scottish system. We've had miscarriages, but very few by comparison. Is it really within the Cabinet Secretary's view that we can be as cavalier as this? We've motored on this subject in a matter of months to consider all these issues, and as a government, you're saying you're open to suggestions from the sort of public and the committee and others. Surely it should have been for the administration to come forward with a comprehensive suggestion of the next way forward, instead of saying we'll take this one brick out, and if you're worried about the foundations, come up with a few suggestions.
Well, we're building upon Lord Carloway's review here, so this wasn't done by officials.
This isn't Lord Carloway's system. This is Scottish justice we're talking about here, and we've got a community who have really said they are very concerned about the issues, and they would seek to deliver justice for victims too, as all we would.
Well, I think, first of all, let's deal with the question of justice. I can't comment on, I don't know, the cases that you referred to south of the border. That might be other aspects of their system. I don't think you could necessarily say they were all related to corroboration, and it wouldn't be for me to be able to comment on that. Equally, I think it's quite clear that the other countries in ECHR and elsewhere and the Commonwealth who don't operate corroboration, as far as I'm seeing, I'm not aware of manifest injustices in Scandinavia or indeed Canada, New Zealand or Australia being countries where, you know, great injustices doubtlessly will. Miscarriage of justice also apply in Scotland. Yes. It's for those reasons that we have quite correctly, and it's tribute to, you know, my predecessors who brought in, you know, the Scottish Criminal Case Review Commission, because occasionally the system does not get it right. So I think we should recognise that corroboration hasn't avoided miscarriages here. Equally, the lack of corroboration hasn't resulted in miscarriages elsewhere. They occur for a variety of reasons. We have, and we're one of the few countries that do have a Criminal Case Review Commission, and I think that's a tribute and a testimony to the serious view that we take of it. So, as I say, that comes back to the position there. I think very few people are arguing for the retention of corroboration. I think an awful lot of people are expressing concerns about the new landscape after corroboration has gone, and that is understandable. Very, very few, it seems to me, have come here to say that corroboration must stay. I think, you know, even they would probably caveat it by it should go to some commission or whatever. What we are happy to do as an administration has been, first of all, we did carry out a consultation into safeguards. That was carried out after the initial Carloway report. That was the one where it was the Senators of the College of Justice, for example, that did not seek to have the right to remove the case from the jury. Equally, I'm happy to take a contrary view, you know, to the senators on that. They were the ones that were happy with 2/3, but we are open to taking further time to get the new landscape right. But as I say, I come back to the point, I think corroboration is shown to be archaic, and those are Lord Carloway's words, not mine.
I'm conscious I'm a guest of the committee. If I can just ask one last one.
Very good to guests.
You've said that you will take time. Would it be within the view of government that they would accept an amendment which, if they got their way in terms of the future of corroboration, they would not empower those changes until some group reported on the appropriate checks and balances to be put in place when this change to the approach to corroboration occurs?
Well, of course, because I don't think you can go from the old regime to the new regime without, as I say, making sure you've got it right. And if what I am saying is that we've got to make sure we've got to get it right, we've got to give that time. But as I say, the principle of removing corroboration has to be adhered to. We do have to make sure, and I'm happy to make sure we take the time to get it right. And equally, I'm conscious, as you'll be aware through your professional background, we also have to train up not just police officers, the judiciary, the prosecutors for the new landscape. So there's going to have to be some delay in terms of implementation.
But before that training can take place, that new landscape needs to be clarified and understood. And that element of whether it be the Scottish Law Commission or some other structure, something needs to be clear to us at this stage how you would do that.
Well, yes. I mean, we're happy to take the time to get it right. And equally, as I say, we're conscious that you can't start training people till you've decided that. But equally, we're conscious that this is a busy year with strain on the police with Commonwealth Games, etc. And therefore it has never been anticipated that police training would be beginning until a considerable period.
Can I just clarify what you're actually saying? Because you've come up with a lot of substantive, not firm proposals, but tests about other tests that you'd put in place if corroboration were to go. And I, for the life of me, can't see how we can deal with these at stage 2 or indeed at stage 3 when you'd have to take certainly at stage 2 further evidence. And, are you saying that you would keep corroboration in the bill, but it wouldn't be enforced pending something else?
No, what I'm saying is that corroboration has to go, and we believe that that has to remain in the bill, and we've got to trigger that. The point made by Mr Pearson's a perfectly valid point, though, that we were never anticipating that when royal assent came in that you were immediately going to go live, because the likelihood is royal assent would have come in before training, etc. had come through. And we also recognise that we have to make sure that we get the landscape right and the balance of the scales of justice right. So we think what we have to do is to remain committed to the removal of corroboration, to adhere to the principles set down by Lord Carloway, to ensure that the due change does not come in until such time as we have got right the new landscape for prosecution and indeed the judiciary to decide upon when matters come before them.
I'm concerned about the got right and the committee. I mean, would there be a role for the committee? I appreciate what you're saying about this would come in later, but if it's not going to be enacted right away, is there a way, perhaps I shouldn't be asking this, should be asking the clerks, is there a way the committee could ensure, or the Parliament could ensure, that they look at this again prior to, it would be in the bill, and it would be in the Act as passed, but suspended animation, as it were, until such time as further evidence came back to the committee, to allow us to say, OK, now we've taken our time, it's better than trying to do it at stage 2. Maybe I'm asking the wrong question, I don't know.
No, I think these things would be triggered by subordinate legislation, but there are ways through affirmative legislation that matters can come back before the committee and indeed before Parliament. And indeed, I think from discussion with various people, including academics, that would probably provide for greater scrutiny than would be dealt with in any other way.
Come back in on that, Graham.
So, given that thought process that we've delivered on there, it would be your intention that within the bill there would be a commitment to discarding corroboration as a basic requirement, but also a safeguard within the bill which would say, but that discardation, or whatever you call it, would not occur.
That's a new word, Graham.
I'm glad I invented it. Would not occur until a committee or some other vehicle had come forward with safeguards that this committee were satisfied with.
Yes, we are perfectly comfortable with that direction of travel.
I've got Elaine and Sandra on this. Elaine first, then Sandra.
Just a wee supplementary, because again I'm getting a little bit confused, because part of your argument about having to do this in the bill was that there were these thousands of victims who were not getting access to justice, even if they're not getting delivery of justice through this, but they weren't getting access to justice. But you're now arguing that, and I'm to a certain extent reassured by it, but you're now arguing that you would suspend that until a process had been gone through by which the safeguards had been interrogated, which would put it off possibly a couple of years.
No, well, it was never the intention that we would be able to bring the new regime into place into 2015 anyway, because the police had made it quite clear to us that with the Commonwealth Games, with the Ryder Cup, the ability for officers to go for training, whether it's online, whether it's going back to Tullyallen, just could not be done in 2014. So it's always been the intention that the changes would not be triggered, although the bill would go through with royal assent. As is normal with many bills, things come in at different stages. So the changeover was never going to come to 2015. At whatever period of time. So we do have that window of opportunity.
So that your argument about the urgency of doing this was actually irrelevant?
No, I think the urgency is to get it done as quickly as possible, but this is as quickly as it can be done, because it can't be done any quicker than that. I mean, I can't ask the Chief Constable to take officers off the necessary orders that they will have at a busy time for Scotland, and they will have to be trained up. So it was never going to come in until 2015. The period of time of when it was going to come in hadn't even been considered, but it would have been in 2015. That gives us a window of opportunity to get it right. Does that mean that, yes, that some people will suffer and won't get access in 2014? Well, yes, but we were never going to be able to do that. It's about getting it done as quickly as possible. Those are the discussions that we've had with Victim Support Scotland, who support that position. This is about getting it right. Corroboration has to go, but we've got to ensure what we replace it with equally is appropriate, and we'll take time to make sure that we get that right and the timing is right.
Sandra, and I'll take Graham back in.
Thank you very much, Convener. It was a timescale. I was concerned about, having spoken to victim support and others in regards to the corroboration issue. Are you saying, Cabinet Secretary, then that it wouldn't be any longer than 2015? Because my great concern is, whilst we've been talking about the Law Commission, you could talk about 2, 3, even 4 years down the line before something is actually put in statute. So from yourself, if this had to go ahead, it wouldn't be any longer than a year.
Well, I think the Lord President himself, in looking for him question, said it shouldn't take longer than a year. We didn't think you could be training up the police any quicker than a year. So it seems to us that we can use the time that we've got when we can't, as I say, when we have some dead time, if we can put it that way, get it right. But yes, I mean, we want to get the balance right in the scales of justice between doing it as quickly as possible but having sufficient time to get it right. But that does seem to us allows the juncture for some further review, the principle enshrined that corroboration goes, and then triggering it as soon as is possible to end the manifest injustice that so many victims face.
Forgive me, I was just checking. I think because you've thrown in this super affirmative stuff, is that I think the committee at some point will have to find out exactly what that does to primary legislations. I don't think we've done this before in terms of process, but I do know it allows us to take evidence, take it back to the chamber, but what that does to something that's already enacted, because you say it's, Cabinet Secretary, as you say, it's coming in, but that depends on Parliament whether or not corroboration is abolished, and the committee would have to keep its finger on that pulse of the changes. Graham, you want to come in with this change?
I'm grateful. It's on the change. You'll know that this is a new approach that has been shared with us today, that you would set up this kind of review group. Have you thought through who would lead on that group at this time? Would it be the Law Commission with a time scale set that says you report back by X date, or do you see it being led by some other mechanism?
I don't think the Law Commission would be appropriate. I don't think they have the resources available at the present moment to do that. We do have some thoughts, but we're open to any views that the committee may have. But as I say, the principle that we are enshrining as a government, as corroboration goes, we take time to get the safeguards and matters that relate to that correct, and then implement it. And other matters we're happy to discuss with the committee and indeed with other parliamentary groups.
Thank you.
I now get Christian, followed by John Pentland, then Sandra, then Alison, then Margaret.
Good morning, Cabinet Secretary. On that particular point, I would like to know more about the training of police officers. Do you think that we need to wait for all the safeguards to be debated before we start to train police officers?
Not necessarily, but I think it probably would be better. I would have to leave that to police. It would be a matter for them. I mean, the only discussions we've had with the police is that with the Commonwealth Games, with the referendum, with the Ryder Cup, with homecoming, all of that, thereafter police officers, and with Mr Finney sitting next to you, will doubtless be having the Federation saying officers need time off, etc. There was going to be difficulties in having the opportunity for the training that will be required being dealt with in 2014. And on that basis, we'd given a commitment to the police that we wouldn't be proceeding with it this year. I think I'm happy to leave that to the good offices of the police and the Federation. What matters is that they get the training, they get it right. You could probably start doing some of it, but it might be easier to go once everything's sorted. But I think it'd be a matter for them and their staff.
Okay, so it's a question of timing at the end of the day, and we've got to make sure it starts as soon as possible. If we all agree that the removal of corroboration is the way to go forward, which seems to be now the view of the committee, because everybody's talking about timing as opposed to we should remove the requirement for corroboration or not. Now, I will go against the committee on that and trying to go back to it and see if there were suggestions out there that the requirement for corroboration could be abolished only for some cases. Now, on the other hand, we had Lord Gill who came on to give evidence and said that the requirement for corroboration, if removed, should be removed across the board. So did you think about this possibility, and how do you...
We did think about it, but I have to say I think there's good reason why, when you have a law of evidence, it should basically be for all cases. I think the Lord President thought, and it wouldn't be what terminology I would normally use about different categories, but can understand where he's coming from. Why should they, when I have to meet relatives, why should I have to, find myself saying to somebody whose son had been murdered, well, corroboration was required and therefore the case couldn't proceed. And then you speak to somebody who, it was in a rape offence where understandably it did. So I think you create two categories. I think it causes great difficulties for those who operate it, and certainly forensic scientists and police were concerned. You turn up at a crime scene. What crime's been committed? Is this a serious assault, a murder or a sexual offence? I don't know. The victim's unconscious or dead. Well, what law of evidence am I to apply? The law for murder and assault, or the law for rape and sexual offence? Take your pick. All the way through the system, something comes in, forensics to be addressed. The forensic scientist would normally know what to do. Is this to be corroborated? Is it not to be corroborated? Going to find out if it's this. What happens when a rape victim, and sometimes this happens, what happens when a rape victim dies? You started out with no corroboration, and all of a sudden, the law changes. So I think when you have laws of evidence, in the main, they should be, clear across the board. So we did give consideration to it, but the Lord President was opposed to it, the Faculty of Advocates are opposed to it, and I think all my evidence of forensic science and the police, I think, whilst superficially it might be easy to say, if we do rape and sex offences, that's it. Well, what happens to the old lady who's a victim of some scamming? You say, well, sorry, corroboration's required here. Or the assault on a vulnerable victim. I just think at the end of the day, both in terms of implementation and operation, it becomes too difficult for those having to turn up and say, what rule of evidence am I to apply today? I think there should be one law of evidence.
At least it was an alternative to your proposals. Is there any other alternatives out there to your proposals?
Well, I think the alternatives to a proposal to abolish the law of corroboration and routine requirement is basically to ensure that we have the appropriate safeguards and the system fits together and the checks and balances. That's it. That's what operates in all other regimes. You know, reference has been made to us, oh, the Netherlands has corroboration. No, it doesn't. The Netherlands is something much more akin to what the Lord Advocate is advising, which is there should always be supportive evidence. I'm comfortable in that. It doesn't require it to be at the beginning. It doesn't require the 2 officers to go for the CD-ROM or anything such as that. So no other country has come to there. And I always remember my first discussions with Lord Carloway about this, because he said he tried to work out, why did we bring in corroboration? What law did it come in? When did it come in? And he said he couldn't trace it. As far as he could see, it came in from Romano-canonical law. Now, it does seem to me that Scotland and the world is a different place from when we routinely applied Romano-canonical law in Scotland. On that basis, I can't see any alternative other than to ensure that we get the best safeguards, have the right landscape, and basically go down the direction that most other modern Western European democracies go down.
Taking that particular example in Netherlands, we heard from evidence from some University of Dundee.
Before you go to that, I'm coming back to what people wanting supplementaries with regard to, I take it there being 2 different kinds of cases. Is this on the law of evidence? So that, yes, so I'll take Margaret first. And John, you're on the same point, are you? Margaret first.
Yeah,
because you're on to a different point, are you?
Cabinet Secretary, if you listen to Lord Gill, then he made it quite clear that corroboration have evolved over the centuries to where we are now. From your evidence this morning, it seems to me you're suggesting every single fact in the case should be corroborated. And the sad fact is that that is the way the prosecution has very often been looking at cases. What's needing looked at is the law of evidence here and how the fiscals are actually applying it in course, because there isn't a high threshold for evidence. All that's required to establish corroboration is the essential facts of a case are backed up by 2 sources. 1, a crime is committed. 2, an accused did it. So I think half of the problem or half of the concern about this prosecutorial test that you're talking about is, in practice, the law of evidence is not being applied properly in the courts just now.
Well, I have to say, I don't know. I mean, what are you suggesting, that the Lord Advocate has got it wrong? His predecessor, Eilish Angelini, wasn't applying it correctly. Lord Hardy was incompetent. Lord Boyd didn't get it right. I have to say, I practiced law for 20 years. I've always understood to be the position as articulated here by the Lord Advocate. It's for that reasons that you did have evidence, I think, from ACC Malcolm Graham. It's not simply what happens in the court. It is that strain running right through. It is for those reasons that we do have 2 officers going for a CD-ROM. We do have 2 forensic scientists. And if we don't, then you get no case to answer challenges saying that matter hasn't been corroborated. Not simply the sexual assault aspect, you'll get aspects further down the line that it was a failure to corroborate. So it seems to me
Margaret, stop a minute. Margaret, no, stop
every
a minute,
Lord Advocate has got
Margaret,
it wrong.
Of evidence, the skewed one.
Stop a minute. I thought that you were going to ask about the test, because you are on my list, to ask about the test with two different types, whether you could have no need for mandatory corroboration in certain cases. Is that what you're going to ask about?
It was a follow-on to the issue of the investigation of crime and Romano law that was referred to that I would like to ask about.
I'll leave it. I'll let you back in later, because I'll let it go on with, because I thought it was that particular specific aspect, but why you say whatever happens has to happen across the whole piece and not the separate categories of offence.
Yeah, thank you very much.
Christian.
I would like to go back into the Netherlands case. We heard from 2 professors, Professor Pamela Ferguson and Professor Fiona Reid from University of Dundee, both from University of Dundee. And they came back to us telling us that they heard that Scotland was bizarre in having its corroboration requirement. But they said that they are practicing, when we thought about it in Netherlands, what they're having, it's exactly this it's not a formal requirement, but they do have corroboration which operates unofficially, and it's like in many jurisdictions. And that leads me to think we're removing the requirement for corroboration a lot more seamless than first expected.
Well, I think you're right. I mean, I think, you know, I disagree with what Margaret Mitchell is suggesting is the current law of evidence, and I think that's why the Fiscal's Office have always operated in this way. But I do think that it's unnecessary. Equally, the points that you make about the Netherlands, I think, are where the Lord Advocate has specified he sees this position requiring to be that there should always be additional evidence. So yes, I think you know I don't think I would view that the Netherlands operates corroboration, but it does require additional evidence, and I think every right-minded person would expect that, because it comes back to the fundamental point raised initially by Elaine Murray. We do not want a situation where one police officer or one individual makes an accusation and that is sufficient for a conviction. That is not going to apply. That is not and will not be acceptable. There will always have to be the additional evidence, and equally it would seem to me that the cases put forward in evidence by the Lord Advocate, whether the rape of the woman in her own home or if the child indecently assaulted, there's certainly additional evidence there that would have proceeded in the Netherlands that can't proceed in Scotland because of corroboration. So I think seamless, maybe not entirely seamless, but I think the point you make, if we can accept, and I think Margaret Mitchell is trying to make the point, it'll be for her to say that a lot of what is viewed as perhaps needless corroboration. I just don't think that it currently can be dispensed with simply by the Lord Advocate saying I'm not going to have corroborated evidence in terms of that CD-ROM, because there have been far too many cases where that case has fallen because an aspect in the build-up or the preparatory matter wasn't corroborated, and therefore no evidence, there was no outcome there.
Thank you. I've got John Pentland, followed by Sandra, followed by Alison, followed by Margaret. John Pentland.
Thank you, Convener. Convener, we're now in our 11th evidence session, and I'm still unsure whether the Mexican standoff, will be avoided. That will remain to be seen. But I'm just wondering, in your opening remarks, Cabinet Secretary, whether you were perhaps softening and pursuing an all-or-nothing approach to this. And, when you talk about, taking on board suggestions and perhaps compromises. And it was on that point that, bearing in mind there is a conflicting evidence that exists, it was interesting to note that both Lord Cullen and Hamilton have said that limited exclusions from the requirement for corroboration would be a better alternative than the complete removal. Would this perhaps be one of the compromises that you would be prepared to reach?
No, I have the greatest respect for Lord Cullen and for Lord Hamilton. I was very grateful for the contributions they make, but equally their suggestion about a limited change was rebutted by, I think, by others. So I think what we're quite clear, and I'm quite clear, is that the case against corroboration is made. We are not softening in any shape or form on that, but we do accept that there are concerns about the number of safeguards, how the system in the new landscape that would exist with corroboration going would exist, and we're happy to take the time to get that right. I don't think you could have a partial removal of corroboration. I think corroboration is past its sell-by date when it came from Romano-canonical law and isn't applied in any other jurisdiction. Equally, we probably want to ensure that, given we're coming later into the game, that the new jurisdiction that we will operate here in the new system, let's make sure that we get the best aspects from wherever and make sure it's fit for purpose in our land.
Cabinet Secretary, you make great emphasis, and it's one I support, that with regards to we really need to get access to justice for those rape victims and sexual assaults and domestic abuse. That is something that I would certainly support. But have you ever looked at any other alternative as to the removal of corroboration?
We see corroboration is not sacrosanct. I mean, the point we made, corroboration, when it first came in, would have been 2 eyewitnesses to speak to a matter. It came in a world when we didn't have CCTV, we didn't have forensic science, we didn't have, certainty that it was 3 million to 1, that there was all these aspects. All of these things have changed. It came in when we didn't have a professional legal defence team, when all these other aspects came about. So the world has changed equally over that course, because justice was being denied for good reasons. The court brought in matters such as Murov, a fundamental change to corroboration. They brought in Murov. Murov has been tweaked, changed, ameliorated, broadened, because it just wasn't working. It still doesn't provide everything. So there's been wholesale changes to the law of corroboration throughout the years. That's why I think it has long since passed its sell-by date. It actually causes more difficulties because it's, unclear. And when I'm speaking to, learned academics, and they cannot tell me that we can get an agreement of just what the definition of corroboration is, then we have a problem. So I think corroboration has to go. What we then have to do is to make sure that we get the alternatives right. But I don't see how it can be tweaked. It's been tweaked, probably even within my period of, tenure as a lawyer. Murov was further broadened.
One final question.
Of course, John.
Because there is such widespread opposition to the bill, if it is unsuccessful, do you have a plan B?
Well, I don't think there is widespread opposition. I accept the concerns within the legal profession. But let's remember, on the other side, we have Victim Support Scotland, Scottish Women's Aid, Rape Crisis Scotland, Police Scotland, Scottish Police Federation, ASPs. So I think that, yes, there are understandable concerns from the legal profession, and I don't seek to minimise the concerns they have, which I think are understandable concerns about making sure that whatever we move to is right. But I do think that the case is made, because I think overwhelmingly those who are suffering from injustice are seeking that change, and that's a removal of corroboration.
And do you have a plan B, Cabinet Secretary, if it is unsuccessful?
No, I think we've got a plan here to deliver access to justice, and, as I say, to take time to get the safeguards and the changes to the system right.
Thank you very much. Sandra, please.
Convener, and good morning, everyone. Following on from my colleague John, absolutely concur with what he said about the corroboration issue and access to justice for areas of crime, which basically people are victims of. Whilst my other colleagues, John mentioned and others, have mentioned the fact of the judiciary, mostly all against getting rid of corroboration, it has also been mentioned, and I don't know if you'll agree with me here, Cabinet Secretary, by a number of the judiciary, that if they were starting afresh, corroboration would not be part of a law. So, have you heard that? Would that be?
Well, I think that comes back to it seems to be that most of the opposition is not about preserving corroboration, because I think everybody accepts the difficulties that exist. That when you cannot define it, I always take the view that in the main, law should be understandable to the general public, not just to lawyers. We have a position where corroboration isn't even understandable in some instances to the legal profession. That what would be viewed as corroboration by one is disagreed with. Because let's remember, some of the casework that the Lord Advocate put forward as cases not capable of going forward were disagreed by one of Scotland's foremost legal professors, who said, yes, they are. Now, either it is or it isn't capable of going forward to a court case. So when you have that position that people cannot write down in 1 or 2 pages, what is the law of corroboration in Scotland? Is it 2 witnesses for everything? Well, no. Well, is it, it's not that. What is it? Is it in every case? Well, not in every case. Well, what case is it not in? It's not capable of being understood. So I think you cannot tweak it or refine it. It's been done over hundreds of years. The time has now come to actually look at what works elsewhere And Graham Pearson makes a right point about making sure we do protect ourselves from miscarriages of justice. That's why we can make sure we look at what happens elsewhere, whether it's in the Netherlands, build that in, but give people the right to access justice when there is, as I say, a sufficiency of evidence. Make sure we get the safeguards right, but I don't think you can tweak it.
I was just thinking that definition, being unable to define or to describe something, is not always means that there isn't such a thing. It's like an elephant. I mean, you know an elephant when you see it, but very difficult to define and describe so that it's, everybody, without seeing one, knows what it means. Well, whereas a judge sitting there will, or jury might very well know corroboration when it comes across because of the facts and circumstances of the case.
Well, I would accept that argument in a lot of spheres of society, but in a court of law, when you're talking about, matters that relate to imprisonment, to justice, when you say, well, we don't know, we'll know it when it comes in the room. No, we should know what it is, and it should be understandable. And when you cannot get the academics or the judiciary to agree upon what the law of corroboration is, then you're left to individuals, arguably having to just make a decision on, and probably the right decision, to try and get towards access to justice, but there's something fundamentally wrong there. There are some areas of law, in terms of, IT or, conveyancing and land law, that are very, very complex and won't be understandable to the ordinary man or woman. And the same with some law of evidence. But something as fundamental as this, that superficially would appear to be so simple, it's just you always require two things. Once it gets into, well, it's not that, then I think actually that law is no longer fit for purpose. But it's not so much the intellectual argument that matters. What matters is 3,000 victims are not able to get access to justice every year.
Absolutely. Jay, could I follow up on that particular point?
I still stick by my elephant example, but there we are.
There's two types of elephants as well, by the way, not just one. But I'm not a lawyer. I'm not the judiciary. I may be an MSP, but I'm a member of the public, and I think you're absolutely right, Cabinet Secretary. The public should know exactly how the law works. It should be for them and not just for higher echelons of intelligence, or whatever you want to call it. But I wanted to move on from that. There has been arguments here, discussions and disagreements. If corroboration is removed, whether that will lead to further prosecutions in that respect. And I noted your opening remarks about access to justice and Colette Barry's. I don't know if you would agree with me in this, and I've spoken to Women's Aid, and certainly I agree with what they say, is that for many, many years, domestic violence was hidden. And as it came forward and people were heard in courts, whether it was prosecutions or not, more people reported it. Would you agree with me that as this moves forward without corroboration, that is removed, more people will feel more comfortable to report it, and therefore more people will come forward, and that will lead eventually, maybe not in 6 months or a year, but it will lead eventually to juries and others looking at the change in the culture towards, not just domestic abuse, but rape and sexual assault and other issues that, older people in homes who don't have a witness to an assault.
Well, you would hope so. I mean, I think all the evidence is that, we're seeing an increase in sexual offences. And I think the reason for that is that people are feeling more comfortable about reporting it, that it's going to be dealt with better by the police, by the prosecution. They'll be better protected in court. There would be better outcomes. So I think if people feel more secure that the law will support them in the challenges that they face, then they're more likely to proceed to report it. Because I don't believe that there's necessarily more sexual offences being committed now than before. I think what's happening is that more sexual offences are being reported now than before. And I think, therefore, that the point you make has merit. Obviously, there's a variety of factors that we don't know in terms of why juries come to decisions, and we've never done that. But I think if people feel that the law provides support for them as victims, then they're more likely to report crime and to go through with all the stages that can be traumatic for them.
Thank you, Chair.
Sandra, thank you. Alison, followed by Margaret.
Thank you. Cabinet Secretary, over the last couple of years you've used your parliamentary majority to drive through legislation that's been controversial, and I think of offensive behaviour at football or the creation of the single police force. And at both of those occasions, you've sat in front of this committee and you're very chirpy and friendly and confident way told us that everything was fine and there was nothing to worry about. And very quickly, as the legislation was implemented, we've seen that it has had flaws in it. We're at quite a critical stage with this legislation, and we've had a host of voices in this committee giving us evidence. I think, given us wise counsel, cautioning against this move, why are you deaf to that?
Because I listen to the voices respectfully that have concerns about the removal of the routine requirement of corroboration, but I can't ignore the fact that not tens, not hundreds, but thousands of people are denied access to justice. And perhaps the difference might be that I can understand for the judiciary, they apply the law, and they'll say that justice was done. They wouldn't even necessarily see it. The lawyers will submit their fee note or whatever and say they did their job. I actually have, it goes with the turf, I have to meet the victims of crime who don't get access to justice. I meet with Colette Barry. I'll be meeting with the woman who gave her story to the Herald recently because she contacted me. I have to listen to their stories, and they're quite, they're very poignant. I think there's something manifestly wrong when I have to say, as Justice Secretary, well, that's the law. But when they tell me that they're denied access for justice, I think I've got an obligation for them, for the others, for Victim Support Scotland, to actually make a change for the better.
I would put it to you that you have an obligation to protect the justice system in Scotland, not to offer false hopes to people, because there is a very real concern that what you're doing is raising false hopes about prosecutions and convictions. And if all that you're doing is trading false hopes for a compromise in the justice system, that to me is not a good way forward. You've spoken a lot this morning. You keep saying, we must get it right, we must get it right, but you seem to have the cart before the horse at the moment. You've said it's essential to abolish this. You've now started to acknowledge that there might need to be some safeguards, but I don't sense that you're doing anything proactively to identify what kind of web of safeguards that you need to put in place. And therefore I put it to you that there would be some sense in doing what many of us have called for many, many months, is to ask either the Law Commission or a Royal Commission to look at the whole process rather than to somehow muddle through, which is what we're beginning to get now, is a bit of a muddle, isn't it?
No, first of all, on access to justice, no, I don't believe I'm raising false hope. I go back to the point I made earlier about Colette Barry. Colette Barry was quite clear when I said, look, I can't, bring in, it's not for me or anybody ever in government or in politics to impose a conviction. It's about access to justice. She accepts that. She did say that she would be deeply disappointed if, there weren't. She believes that the likelihood is there will be more convictions, but she accepts that it's about access to justice. So I don't think we've ever given false hope, and that's the position with Rape Crisis Scotland, Victim Support Scotland, and indeed Scottish Women's Aid as organisations. But I think Colette, probably because of the strength of her testimony, I think is what sticks in my mind as most of all. In terms of safeguards, no, we've always been this. It was that for that reason. Once Lord Carloway did his report, we did a further review on safeguards, including taking on view the comments of the Senators of the College of Justice, of some aspects of which, such as the no case to answer submission, if we can put it that way, the right of the judiciary to take the case away from the jury. We're happy to consider, if the committee feels fit, that actually we should not take the Senator's view on that. And equally, I said then, I said since, and I say again, we are open to any other suggestions, and that's why when I meet with James Wolfe and he raises the issue of doc identification, fine, let's have a look at that. I accept that in 21st century, doc ID has moved on from what it was when somebody was charged with stealing a horse or whatever, back in the 19th century. So we are happy to take time to get it right. But as I say, I do believe that the right of access to justice for victims such as Colette Barry is sacrosanct.
Do you not think, I want to press you on this, Cabinet Secretary, that this kind of pick and mix approach of some of us throwing in some amendments at stage 2 and other people coming forward with things puts at risk the integrity of the system? Is it not better to look in the round at all of the possible safeguards that you would need and to come up with, as I think Graham Pearson suggested earlier, a comprehensive package that gives everyone the assurances that there are strong foundations still that will protect against miscarriages of justice?
Well, you know, that's what we are seeking to do, and I think that's where hopefully we can get to. I don't believe that a Royal Commission would be appropriate, nor do I believe that the Scottish Law Commission is currently in a position to accept a review. But we do have time to make sure that we can give some consideration here to making sure that the system will operate fairly for all, not just for victims, but for the accused. And I think that can be dealt with and that we can keep matters on course here. And I'll take on board views that you and your committee members may have about how it can be dealt with. But, you know, we're currently engaging with individuals and organisations to make sure that we get the appropriate, we take on board the appropriate safeguards and interoperability of the system and thereafter.
How are you going to determine it when you've got it right? What's the test?
Well, that will ultimately be for Parliament.
Can I return therefore to which I think I agree with very much that Alice McInnes is saying. It does seem that ad hoc matters are being raised about safeguards. I don't know if the Cabinet Secretary actually said that if the committee were to give us to give consideration to supra-affirmative procedure, if you would be amenable to that.
I'm happy to look at that, yeah.
Well, just before I take Margaret, I'll make this plain because you might want to focus the questions on this. I've got a note from the clerks of what that would mean because I wasn't too clear myself. The commencement of the provisions on corroboration, if they were kept in the bill, could be subject to affirmative or supra-affirmative procedure. This would need to be specified in the bill. Affirmative procedure would allow the committee to consider whether additional safeguards proposed are sufficient. That would be 3 weeks of evidence. But supra-affirmative procedure, and we've already done that under prison visiting committees, would allow the committee to take more evidence before final orders were laid. There'd then have to be a final supra-affirmative subordinate ledge. That would then be put by a motion by the Government to the Parliament to accept or reject commencement of the provisions of corroboration. Is that okay if I explain that? So that's how it would work. Just as we're proceeding along this line about real concerns around the committee about safeguards and so on, that's a procedural way. Is this on this matter as well, Elaine? I just thought I'd better explain what it is, because it doesn't come up very often.
It's actually on the matter raised by Alison in regard to the Law Commission. I mean, you've been very reluctant to refer this to the Law Commission. However, the Government has suggested that the third verdict be referred to the Law Commission. Yes, last week we heard that Section 53 of the Title Conditions of Scotland Act is to be referred to the Law Commission. Why the reluctance to something as fundamental as the abolition of the requirement for corroboration and what has to come in its place? Why is the Government so reluctant to refer that to the Law Commission?
Well, I think the current view is that the Law Commission is not necessarily best placed at the present moment because of the nature of its staffing, which is very wide-ranging to deal with matters such as law, land aspects, perhaps best suited on criminal matters at the present moment. So we don't think that the Law Commission is the appropriate place to go at the present moment. Also, it's got a pretty full calendar because of everything that has been put there and their ongoing research that they have. They've put out their work programme, and therefore I think the difficulties is that they're probably lacking in this specific criminal skills at the present moment, and also are limited in terms of the time and ability they have.
That's not the case for the third verdict.
Well, they have some equally. We had discussed that with them. They were going to take that on board. They have a new commissioner going in terms of Lord Pentland. But their resources in terms of criminal staff are not great or huge in number.
Yes, sorry, Roderick, you had a supplementary to that.
Just in terms of clarification, it's my understanding in terms of Section 53 of the Title and Conditions Act, the Scottish Law Commission couldn't commence work until 2015 anyway.
Well, I think that's it. They've published their work programme. I can't remember for how many years, but they are pretty busy. They do criminal work, but I think Patrick Layden is on his own at the present moment, if I recall, having to do everything.
Yeah.
I think we deal with this red herring of this affirmative, super affirmative suggestion you've thrown in the pot this morning, Cabinet Secretary. All it does is means the government would use its parliamentary majority to force through a decision that is causing widespread concern. Because what isn't in doubt this morning is you and I both agree what's crucial here is access to justice. You said this morning it's the 3,000 victims of serious sexual assault that don't get access to justice. The other side of the coin is the hundreds and thousands of people who do go through our criminal justice system every year and do get a right to a fair trial. That's what's in jeopardy. And you're also raising the prospect of many more unsafe convictions. And you're doing this, it seems, because Lord Carloway and your own experience some time ago now as a prosecutor in court has led you to believe the case has been made for corroboration. Although this morning, I have to say, it's been confusing your evidence. You suggested early on that the case for corroboration is not proven. I would suggest to you that is the case, that people who have come forward are not saying, absolutely, we must retain it. A lot of us do feel we should, but many are saying, my goodness, why shouldn't we look at it? So I want to just nail this. How long did Lord Carloway spend looking at corroboration? Because it seems to me we have a bill here that covers, and I'll remind the Cabinet Secretary, arrest and custody, arrest by police, custody of persons not officially accused, investigative liberation, police liberation, rights of suspects in custody, police powers and duties. We haven't come to corroboration yet. Breach of liberation conditions, general call of law enactments, and dip application of part, interpretation of parts, sentencing, appeals by SCCRC, miscellaneous. How long did he spend looking at corroboration?
I mean, I think in terms of hearsay evidence, you'd been better to ask Lord Carloway that when he was here.
With respect, Cabinet Secretary, you are saying the case has been made for corroboration because Lord Carloway has convinced me. And you're asking me to go back and ask him how long he spent on it. Didn't you ask him?
It's not a matter to go back. You had him before as a witness. You should probably have asked him that.
Shouldn't you have satisfied yourself before you...
Can we not just have a Barney over each other? Questions, passions, wonderful.
I think it was difficult to understand what the question
Do you know,
was. I think the question was, what period of time of the 1 year that Lord Carloway carried out his review did he spend on corroboration?
Yes.
I have to give you the answer, Ms Mitchell, that I cannot answer that. I don't know how long he had for coffee breaks, how long was applied to anything else. He was asked to carry out a review. He was appointed not by me, he was appointed by the Lord President. He took time off sitting on the bench
You've
to
answered
go
the
away
question.
and
You don't
investigate
know. You don't
this.
know, Cabinet Secretary.
No, I don't know. You would need to ask Lord
Well,
Carloway.
I think that's fairly material if we're talking about some evidence that he's produced that has convinced you overwhelmingly that the case for corroboration has been made. Can I turn to the Carloway Expert Review Group? Do you know what they recommended?
I know well, they were split because some didn't agree and some did agree.
But do you know what they recommended?
Well, they were a reference group to Lord Carloway. It's Lord Carloway's report that is put to me.
You don't know what they recommended. I'll tell you then. Because we heard evidence on it. They recommended that corroboration be put to a law commission.
They were a reference group to Lord Carloway.
Yes, and that's what they recommended to Lord Carloway.
And Lord Carloway
So it
made
seems
a
you
report.
didn't know that, Cabinet Secretary.
Please, just don't talk over each other, just one at a time, because I'm difficult
Lord
to
Carloway,
Did you know that, Lord Cabinet Secretary?
Lord Carloway made a report to me. He was appointed with... Goodbye. I asked the Lord President for a judge to carry out a review after the Cadder decision. The Lord President appointed Lord Carloway. Lord Carloway had a reference group to give him support, advice or whatever. He was the one that carried out a report. He submitted that report to me. I am aware that many in the reference group did not agree with his position on corroboration. Others, including the former Chief Constable of Lothian and Borders, David Strang, did. It was the report that came to me, and as I say, I support that report equally. It would also, to be fair to say, Ms Mitchell, that what has pervaded me most of all about the requirement for corroboration to go is not the eloquence of Lord Carloway or any other legal practitioner. It's hearing the testimony of Colette Barry. She hasn't given evidence here. She would be happy to give evidence, whether to the committee or...
Let's not go off at any more of a tangent, Cabinet Secretary. You're an expert at doing this, but I think you owe it to people, the criminal justice system and the thousands, hundreds of thousands going through it every year who expect a fair trial, to take this seriously and not go off at tangents.
Well, I think, in fairness to the Cabinet Secretary, I don't think he's not taking it serious. I know you're at completely opposite ends of the spectrum,
to go off at a tangent.
But I think that's most unfair. Can I ask... I accept your position on this, Margaret. Could you test out some more questions? I think
the question is, you've said that there's an immediacy about this, that we must get justice for these victims now. At the same time, you've said it's important that we get it right. We take time to get it right. Cabinet Secretary, you have in the SNP government a majority. Surely any reasonable person, given the weight of expert opinion that we've had, and there has been a very damaging attempt to polarise that opinion in these groups as the judiciary and the legal profession on one side and the victims on the other. That does a huge disservice to the victims, as we know from the evidence from, for example, the adult survivors of sexual abuse, who are very firmly of the opinion the rights of the accused must be protected in order to get a fair trial for their victims and to ensure justice is done. So I think it does a disservice to try a numbers game and to polarise it. Given all of this, given your testimony today, you want to get it right, given you haven't a clue how long Lord Carloway spent looking at corroboration, isn't the reasonable thing to do not to give it to a law commission who you say are far too busy? We accept that. But to, as Lord Gill suggested, set up a royal commission to look at this now while we're looking at the law of evidence, which clearly, from the evidence we've heard and things you have said, is not being applied properly in court, and where there is room to make this corroboration, which you said is whittled down. Contradictory evidence. It's supposed to be a barrier on one side, it's whittled down to actually nothing in the other. Given all of these statements, surely any reasonable person would say, while we're looking at possible safeguards, we look at corroboration itself and whether to retain or abolish.
No.
Any reasonable person, I did say, Cabinet Secretary.
Well, now I'm not having. Please, let's contain our emotions here. I think that because we've not asked you this for completeness. There was a petition looking for retrospective application. Should the rule for corroboration, mandatory corroboration, be abolished? I would ask for the record, Cabinet Secretary, to address that point.
I don't think retrospectivity can be.
Could you just develop that a little bit?
Well,
After all, somebody's taken the trouble to bring a petition to Parliament on it, and I think it would be helpful.
I think it would cause great difficulties for prosecution. I appreciate the sensitivity here because people who have suffered injustice, but I think there has to be some clarity and certainty. It does come back, I would say, Ms Mitchell, to some of the point. The law has got to be understandable. People have to know whether the law applies to them or it doesn't apply to them. And I think the retrospectivity causes difficulties there. So I think, as I say, our position at the present moment is that retrospectivity wouldn't be possible, despite, as I say, I know and I have sympathy for those who seek to have it brought in.
Thank you. John?
Thank you. I don't know, has Margaret finished her? Yes, sir, thanks.
Just
in case you thought it was a supplementary.
No.
It's about Romano, whatever law, Romano Greco.
Romano canonical.
Cabinet Secretary, thank you for yes, indeed. Thefts, horse thefts and the like. And you said a lot has changed since then, and that is the case, Cabinet Secretary, because we now have CCTV, there's IT, mobile telephones, forensic science, DNA, record number of police officers. All the more reason there is to be able to acquire corroborative evidence, many would say.
Well, it's about justice. And see, one of the interesting discussions I did actually have with the Scottish Human Rights Commissioner and his colleagues, and indeed it was before, so we know at some stage or other, because of ECHR, a victim might choose eventually to go to Europe to challenge the system because they're not getting access to justice. Because people have gone to Europe frequently about convictions or whatever, but at some stage or other it would be open or possible, and Scotland could face significant difficulties if we were challenged. We have the UN report relating to sexual offences, so I think we've got to prepare, and certainly I think the SHRC accept that it is within the bounds of credibility that such a challenge could come. Just perhaps, as in other instances, the poor and the victims tend not to have the access to the lawyers, and it's not been brought so far. So one of other aspects of this is making sure that Scots laws fit for purpose can sustain challenges from ECHR or whatever, and actually, as I say, provides that correct equilibrium for the scales of justice.
The Scottish Government's position is that Scots law as it stands at the moment with the requirement for corroboration is challengeable under ECHR.
It could be challenged, yes.
That doesn't feature in any of the representations, explanatory notes or any of the policy memoranda or anything like that we've had before. When did that come to light, Cabinet Secretary?
Oh, it's been a matter I've had discussed with past Lord Advocates.
But yet we have nothing in our papers to suggest that, and that is something of, I would have thought, great significance.
Well, I think the Lord Advocates expressed concerns, but as I say, I've certainly had discussions, not simply with the current Lord Advocate, but with past Lord Advocate, that ultimately we would face or could face difficulties if a challenge was brought.
What changes in work practices and attitudes were this requirement for corroboration to be removed from the Scots law system, do you think there would be, particularly with regard to police officers? I asked Mr Graham about the amount of effort a police officer would put into someone who was the subject of a single witness accusation, perhaps with some CCTV or whatever. Would the police be going out looking for evidence that would support his assertion that he hadn't?
Well, yes, because if, as we accept the position of the Lord Advocate, you'd always be looking for additional evidence. Probably the easiest thing would be once you'd heard from one witness, you would try to get a second or third witness. It would only be in cases where you were restricted in terms of witnesses that you wouldn't be seeking, to try and get that, and you'd be looking for additional evidence. So I think the work practices of the police would remain exactly the same. If there were an incident and there was a large number of witnesses there, you would get as many as possible. You might only cite a few of them, but that's probably the situation at the present moment. You would have been with it yourself. There would be instances where there might have been 100 people saw an offence. Doesn't mean you would call all 100. You would probably have noted those, but you would make sure that matters were brought. So I don't think it will make any difference to the work practices of police. I think what this does, though, is ensure that apart from the two officers having to go down to London, etc., for matters such as that you'll probably experienced yourself, where there's a duplication of resources and matters that are not fundamental. But I think in terms of what matters in the kernel, it comes back to what Lord Carley was saying. This is about quality, not quantity of evidence. It's about making sure that the case is proven. It's about making sure that there's a sufficiency of evidence there. And that's why what we're looking at is building upon the qualitative and quantitative test by the Lord Advocate, the evidential and prosecutorial test. Is there sufficiency there? Is it in the public interest? Is there, not just a single source, but is there additional evidence? If there's several sources, that's what you want. If it's a situation with only one eyewitness, and what other additional evidence can you get? Is it that the pants of the perpetrator actually are the same that the young girl known? Is it that she was able to identify a locus that she doesn't know, but is clearly able to express all those things? Those are all the additional evidence at the present moment, because of the arbitrary rule of corroboration, cannot go to trial. But in any other Western democracy would be going forward, it would be for the jury. So I don't think it changes the work practices of the police, apart from getting rid of the duplication that I think is conceded by everybody as unnecessary.
Can I just stop you a minute, because everybody's chipping in again, and I will let this be exhausted but I'm telling you who's waiting to ask questions just for enlightenment. because you're busy doing this, but I've got a lot of people doing this. I've got Roderick, Sandra, Elaine, Christian, and now Alison. So I'm happy to take you all, but let's not go over old ground. Let's pick up new things. Okay. So have you finished? No. You're perched, ready to go.
Just one further area.
Okay.
Cabinet Secretary, and it's regarding domestic violence, and the welcome change certainly from a long time ago when I was in the constabulary. But it is a situation that, following Lord Advocate's guidelines, sees perpetrators, overwhelmingly male, being arrested on uncorroborated evidence and being detained in custody on uncorroborated evidence, only for it not to proceed to court when the fiscal gets the papers in the morning, as I understand. Another dimension that happens with that is, as I understand, the growing practice of counter-accusations. So the alleged victim of the initial accusation finds themselves the subject of an accusation. You have both parties arrested. Under CADA, both parties summon a solicitor. The solicitor gives advice to both parties that it would be inappropriate to say anything, and you have a logjam there, which I don't think is in anyone's interest. Do you fear counter-accusations were you to remove corroboration? Because that's happening with corroboration.
No, I think the issue you raise is a matter that goes to policy operated by Crown and Police. It relates to a zero-tolerance policy. It also relates to, I think, better training for police officers in particular in terms of what they are looking for. I don't think that it makes any difference to the law of corroboration. I don't think that that would affect the policy of the police.
Thanks. Thank you very much. I've got Roderick, then Sandra, please. You're not wanting in now? No. Oh, you are? Roderick.
Yeah, might I just say, for good order, may I refer to my register of interests as a member of the Faculty of Advocates. Just in following on from the point that John Finney was making about ECHR, I think I'm right in saying that Dame Ailish Angelini made a speech on this last year, which was reported on that, so it may not be in the policy memorandum, but certainly something that previous Lord Advocates have talked about.
What did she say?
Basically about the risk if corroboration was abolished of a challenge under ECHR.
Okay, that's helpful.
Yes.
Okay.
I just wanted, again, for good order, just to refer to a comment Lord Gill made in terms of if his suggestion that there should be an examination of the various safeguards in the criminal system in the round, it could, for example, be reconsideration of the admissibility of certain statements, a re-examination of the use that can be made of confessions, re-examination of the right of the accused not to testify, an examination of the right of the accused to withhold his defence at the earliest stage of a prosecution, and so on. In considering safeguards, will you take on board these comments of the Lord President?
Oh, yeah, yes. I mean, I think, some of those aspects might be for other reviews, but I think all of them have to be at least initially considered as to whether they would be, appropriate, because it is, I think, becoming clearer to me that it's not simply safeguards and the number of safeguards, it's the operability of the system and other aspects that you've correctly touched upon from the Lord President. And yes, we're happy to ensure that we take the appropriate steps to ensure that we consider them.
Thank you.
I've got Sandra followed by Elaine, Christian, then Alison.
Just a very small point of clarification. Perhaps the clerks could check this out, similar to what Rod was saying. I seem to recall that Lord Carloway said, in giving evidence, that he was protecting the Scottish Parliament against someone taking a case to the European Court of Human Rights. If we still had
well, that will be that we, in considering our report, we can go back to look at the evidence.
John said he hadn't seen anything, and I'm almost certain it was part of the evidence. So it'd be good.
That's how we'll. It's fine. It'll be when we're looking over that particular issue. We look at the evidence we received. All right. You're beginning to exchange with each other now, which means this has evidence sessions from members of the committee. Elaine.
Yes, thank you, Convener. I wanted to return really to the possibility of putting the requirements for supportive evidence on the face of the bill, which actually changes the bill from being a bill in which the requirement for the need for corroborative evidence is abolished to one where the requirement for corroboration is replaced by the requirement for supportive evidence, which is quite different. Now, I'm actually quite attracted to that, and on the first glance, I find that quite an attractive idea. But I think we would need time to take evidence, because we received a lot of evidence, it is a big file of evidence from people on both sides, to see whether that would actually satisfy some of the concerns that have been raised with us. So would you and on behalf of the Scottish Government be prepared to give time for that in terms of this bill going forward? And secondly, and probably importantly, why didn't you do that in the first place before this bill was ever brought to Parliament?
Well, what we did was go out to consult on safeguards, and as I say, I think it's becoming clear to me that it's not simply safeguards; it's the operability, and we're seeking to try and get as much of a consensus as is possible. Sometimes you can't. When you have on one side those who would say that corroboration can never go and those who think that it has to. Equally, we're persuaded that corroboration has to go. We recognised and did recognise the need for safeguards, which is why we have elaborated on a few. We're aware of ongoing concerns, which is why we've always said the door is open, but even with discussions within the last fortnight or so, doc identification is raised by the Faculty of Advocates, to which we say perfectly happy to give consideration. The point made by Roderick Campbell's well made about other aspects, so we're happy to look at that. It's about getting the balance right, as Sandra White said, within time. We're happy to take time to try and ensure that we get matters right. The principle that corroboration is past its sell-by and archaic, we think, is made. And equally, I do think that you make a good point. This is an opportunity to decide, well, with the removal of corroboration, with a almost, what is it that is necessary to prove a case? And we can take time to make sure that we set that out.
Would that be something that would be incorporated in prosecutorial guidance, which I think you're now considering putting on the face of the bill, if I've kept my bearings during this?
I mean, that would be the prosecutorial test, I think, would go in.
Test, sorry, yes.
Prosecutorial guidance is a matter for the Lord Advocate.
I understand that. Sorry, my mistake. The prosecutorial test, which I think...
And that could go on the face.
I think you're saying you might put on the face of the bill. Would that be there? Would that be a place to put something like that?
Yeah, that would be the place to do it.
Right, OK. Before I get any more confused, Christian followed by Alison. And then I want to move on to have a suspension going to the next session, if that's all right with you.
Thank you, Governor. I don't want you to be more confused on that particular matter, but I am confused on something. What I heard this morning is regarding the number of prosecution and the number of convictions if we remove the requirement for corroboration. I remember at the start of this debate, the people who didn't want to remove the requirement for corroboration claimed that there will be no increase on the cases brought to prosecution. And when I asked Lord Gill about this, he answered no, there would not be an increase. When I pushed him on this, he answered it might increase the number of prosecution. So again, we're not sure about the numbers. Are they increasing or will they not be increasing? Now, regarding conviction, we heard this morning from Margaret Mitchell that many more unsafe convictions could arise if we remove the requirement for corroboration. But Lord Gill said that he was not convinced that it would increase the number of convictions. And I would like your views. What will it be?
Well,
Lord Gill said it would increase the number of convictions.
No,
he said, if you've got it in front of you...
But I'm not convinced that it would increase the number of convictions.
That's correct.
So that doesn't add up many more unsafe convictions.
I beg your pardon. Excuse me a little minute. There's a little bit of a debate to my right. Would you like to say something?
The issue is that the number of cases where there might be a miscarriage of justice, not the number of convictions per se.
Yes. The evidence certainly from the SCCRC was they thought there'd be more unsafe convictions and therefore more appeals coming to them. That was another thing. So there was two things there.
Nevertheless, on the conviction, number of convictions.
I believe that there would be an increase in miscarriages of justice. That was made clear by Lord Carloway, and I'm sure if we get the appropriate safeguards right, that will be absolutely certain. It's for that reason we already have an SCCRC that doesn't apply in many countries, other than I think England, Norway spring to mind. But I don't believe that it would increase the risk of miscarriage of justice. It will increase access to justice. The likelihood is if you increase access to justice, then there will be more convictions, but I cannot, give any confirmation or guarantee that, any particular offence that gets an access to justice will result in a conviction. But I do believe that, as the point raised by Sandra White, more people will be likely to come forward. More people who might have put in a not guilty plea despite the evidence or whatever, or in the hope that the evidence would not hang together, or that there would be some ability to evade justice, might actually plead guilty and acknowledge their offending.
I'm going to move on, Christian, before we get any more. You've got the last word, Alison.
Thank you. Mr MacAskill, in your answer to John Finney, when John asked you about police practice after the abolition of corroboration, you talked about there not being many changes apart from a reduction in the duplication of resources. Have you quantified the savings that might be made in terms of police and forensic services, for example, if you don't have to have all these double office?
No, I think the HM Inspector Constabulary was going to do some work. I don't think he's yet reported on the costs of the duplication. I think it's very hard for them to quantify. I think what you'll find is that it won't make savings as such in terms of financial savings. What it will mean that two officers who had to go down to London to pick up a CD-ROM, maybe...
Two officers in the CD anymore. We don't know about it.
Well, I get this from the Federation of
I know, but
whatever.
Forgive me, Cabinet, please just a moment, Cabinet. Forgive me, we accept it's about the two officers in the CD. If we Google that in after this meeting, I think
well, if you let me conclude, what I would say is that rather than two officers, and I don't need to expand that, except they're going to London, then maybe one officer could go and the other officer would continue to be on the beat in wherever he is, in Aberdeen, Glasgow, and that is replicated. And rather than two forensic scientists doing this, maybe they could get on doing some analysis. They would be able to do the work they're paid to, not simply sign a chitty saying, yeah, I was there too.
No, I just think, I appreciate that. I'm beginning to wonder what was on that CD, but we'll just park that and say, on that particular, we will now finish this particular, we'll suspend the session for 5-minute break, much needed by the convener, I hasten to add, and possibly others, including the Cabinet Secretary. Thank you very much. Thank you. Yes, we're all back now, refreshed, energised, and now on to the second set of questions, which is the Sheriff and Jury proposals in Part 3 of the Bill, and Cabinet Secretary's officials still with us. So can I have questions from members on Sheriff and Jury proposals, please? Not quite the flurry. I don't know why. Not quite the flurry of hands had last time. Margaret.
Cabinet Secretary, just about the proposal to increase the majority for a conviction in juries. Isn't there a problem with that in that if that was looked at as a safeguard, isn't there a problem? And I'm wondering if I'm on the right thing here. That is in the bill.
No, I'm
not.
We're on to.
My apologies.
I think we would take that as being related to the corroborative things, and that moment has passed. So, unless it's about, I hope it's not about a CD. It's definitely not about that. You're not one of the policemen, are you? No, right? No, it's okay. Thank you, John.
Thank you, Convener. Cabinet Secretary. There's some wide-ranging proposals there to improve the business management of the court system. And in the past, I think the introduction of intermediate diets were intended to do a similar purpose. Why will it work this time if it hasn't worked previously?
Well, it's worked in the High Court. I mean, this is obviously Sheriff and Jury, and this is predicated not so much on what was done in terms of changes to the practice of bringing intermediate diets back in the 20th century. This is building upon Lord Bonamy's report in the start of the noughties when we made changes to High Court. It's worked remarkably well there, and it seems to me that what works in the High Court, given the nature of it, should also apply and work reasonably well in Sheriff and Jury. So I think this is a different position from what was taking place in summary. And as I say, I think the comparator is probably with the changes in the High Court.
I acknowledge my experiences from a previous century in relation to these matters. Yes. In relation to the question of the secure email system we heard about and ownership of that, will that provide challenges given the additional number of cases clearly Sheriff Jury compared to High Court?
Well, I think we face challenges with the IT system at the present moment, so there will be challenges, but we know that we've got to make these changes and make them anyway, and I'm confident that Crown prosecutors and everybody will be able to resolve it. It will take time, but across the justice domain, we know that the IT systems require to be improved. They bring challenges, new systems bring challenges, but equally, we're changing the system to get it right.
Okay, thank you very much.
Okay. I've got Roderick, please.
Cabinet Secretary, in the second evidence session we had on this, the representatives of the Faculty of Advocates and indeed Crown Office were present. There was a discussion about the terms of Section 66 in terms of the written record of the state of preparation, whether or not that was a joint statement or whether the prosecution and the defence could both sign and prepare their own statements, and whether the bill needed amending in that respect. Do you have any comments?
We're happy to reflect on that because we're aware of the concerns about who will do what, and so that's a matter that we're happy to go back and review and see what we can resolve.
Fine. Secondly, just in terms of the resource implications of these proposals, any comment on that?
Well, I think we've stated matter in the financial memorandum. There will be increased costs through legal aid, and we have to address that. Equally, there will be savings within the systems and hopefully less citations for not just witnesses and jurors, but for specialist witnesses. So we know that there are issues there to be addressed, but we've quantified them and worked with the relevant agencies and believe that we can manage.
Thank you.
With regard to the written statement about the state of play, as it were, in the trial, when you say you're happy to go back and look at it, can I take it you're sympathetic to there being separate records put in by prosecution and defence? Because I can recall difficulties in civil work with minutes of agreement where one party got the blame when the other party that was dragging their feet.
Well, we're happy to try and make sure that we get it right, but Kathleen, do you want to comment?
Yes, it's something that needs to be considered because if there are separate schedules, it's likely to take sheriffs longer time to assimilate the information. And that's likely to have a more significant impact in the Sheriff Court than it does in the High Court because of the volumes of cases. So that's why we need to give it some further thought.
But you take my point that, you know, if one side, if the Crown's dragging their feet or defence are dragging their feet, at least you would know in terms of them having it in within each side having it in with the appropriate time.
Yes.
Yes, I think, well, I'll press that point no further, but just I do think it's fairer to the parties. Margaret?
Yeah, Section 67, Cabinet Secretary and the compulsory business meetings. The Government has taken the decision that this could be held by electronic means and that the meeting could be held after the indictment but before the first trial, rather than what was recommended by the Bowen Review, which was before indictment. Why was this decision taken, and will the timing make the business management meeting any less effective?
Well, both defence and, I think, prosecution indicated they preferred that it should be post-service of the indictment, would give them an opportunity to focus. And I understand that when Sheriff Principal Bowen appeared here, he actually indicated that he was happy and contented with that. So basically, I think everybody's happy that it should be then. And I can see the logic. The service of the indictment focuses. That's what you face. Prior to that, there's some edging around. So I think we've just gone with what seems to be wanted by all those who will be involved.
What's the Scottish Government done to ensure that resource pressures don't hamper the effective implementation of this reform?
Well, we seek to fund all those agencies and parties involved, from the Scottish Legal Aid Board through the Crown Office and Procurator Fiscal Service and the Scottish Court Service. Each are aware of the challenges. We've taken account of all this. In some areas there will be savings, in other areas there will be expenditure, but we've prepared for it and believe that we're capable of dealing with it.
Certainly the High Court reforms introduced something very similar, and that's worked well. Are there any lessons to be learned from them?
No, I think the lesson to learn is that, you know, we have sheriff and jury, actually sheriff and jury procedure probably has much more to be akin with a High Court. So I think we know that there's a greater volume in sheriff and jury than there is in High Court, but equally the good practice, getting matters resolved earlier has worked well in the High Court. You're quite correct there. And I think Sheriff Bowen, Principal Bowen, looked at that, and we are seeking to expand it. So the challenges are more that there's greater numbers in sheriff and jury, but the principles are the same in terms of focusing early, minimising what has to be discussed or debated, and ensuring that we cause as little inconvenience to people if they don't have to be cited or called.
Thank you.
I mean, I'm reasonably content with most of this part of the bill, but I did want to just probe a little bit about section 65, which makes the changes to the time limits, where the Scottish Government analysis had analysed the responses to the Bowen report as, in terms of some people felt there wasn't a strong justification for change. And I was wondered if you were able to give us any information on the proportion of sheriff and jury custody cases where the court actually agrees to extend the current 110-day limit.
We don't. That information is not recorded, and we don't have it. What we do know is obviously that matters are operating in the High Court following upon Lord Bonamy's review. Equally, we're conscious that I think Lord Bonamy indicated that what he thought, and I quote him, the real jewel in the crown of solemn procedure was that somebody who's remanded, the indictment has to be served within 80 days, and that remains sacrosanct. So the extension from 110 days to 114 days puts solemn procedure at sheriff and jury in line with High Court. We retain the principle that the indictment has to be served within 80 days, but I think it's simply to take into account the complexities that many cases now face with forensics and other aspects.
There is a possibility of extension at the moment, but we don't know how many cases actually require that extension.
The figures are available for the High Court cases, but it's not recorded in MI systems, as I understand, for sheriff and jury cases. It's recorded on the written minute of the court proceedings.
Right. So do we have the figures for the High Court cases?
In the High Court cases, the Scottish Court Service Annual Report 2012 to 2013 showed that it was normal for at least one extension of the 140-day rule in cases.
110-day rule.
110-day rule.
Sorry. It was 140 days in the High Court.
Oh, it's also
already, of course,
sorry,
yeah.
140. Yes, of course. Yes. Will you be monitoring this in terms of the procedure, the extension to the sheriff courts? Would you look at monitoring that in the future so you get some idea whether the 140 days is?
I'm happy to do that. I mean, obviously, High Court cases by their nature are likely to be more complicated than the standard sheriff and jury. But we do accept that, and I think we did state in Sheriff Principal Bowens, we intend to monitor the implementation of the proposal. So, we recognise whether it was 110 days, it was, something that you were done reluctantly. Moving to 140 days makes, I think, even more so that you should be monitoring it to ensure that any extension is only done with some good cause. Clearly, there are checks and balances, and obviously there is the opportunity to again seek bail in some instances.
Well, I think I'm not going to look at anybody. There's nobody got their hands up looking to ask any other questions. So thank you very much, Cabinet Secretary and your officials, for attending. I now am going to move on to item 3. I'll give a couple of minutes, because we're going into private, as agreed earlier, for the public area to clear. Thank you very much.